There is a legally interesting private AVO case before Kurri Kurri Local Court. I'll admit, the private AVO cases make me uncomfortable for a bunch of reasons, and it will take me hours to explain. Deep breath. However, I think they are important to discuss, and I'm just going to focus on the legal aspect. Private AVO cases might end up with an AVO just like the AVO cases that are brought to court by the police. However, the process can be different. The police aren't involved. In my opinion, it can be a bit like a civil case rather than a criminal. So I prefer to call the person who made the application the applicant, not the complainant. And rather than say defendant, I refer to the other party as the respondent. The applicant is seeking an order that protects them from the respondent. The applicant and the respondent in this Kurri case are mature aged women. It's possible they're neighbours. This case has been mentioned a number of times so far this year. I observe these mentions can be quite tense. There's no solicitors involved, and I notice the magistrate spends a lot of time keeping the process on track. The process involves each party submitting their evidence before a hearing date is set. They both get to see each other's evidence before the hearing. And at the most recent mention, there is an issue. The applicant has submitted their evidence. However, the respondent has not filed their evidence. The respondent has brought along a friend who the court allows to assist in the process. Beware, having a friend help you appear is rare, and it needs the court's permission. The friend explains the respondent cannot read or write. The exchange, in my opinion, is tense. The magistrate keeps getting interrupted, and there's tears. After some back and forth, the magistrate makes a decision in the interests of justice. The hearing will go ahead, however, we are to expect 2 hearings. The magistrate decides to allow the respondent to give their evidence orally at the first hearing in November over at Cessnock Local Court. This is to accommodate the respondent's circumstances. And now, because the applicant will only get to hear the evidence at the hearing, in fairness, they will all come back at a later date to give the applicant time to respond to the respondent's evidence. In my opinion, how the hearing will be structured is what makes this case legally interesting. The legal proceedings need to be fair to both parties, and sometimes the court is presented with challenges. I think the case is worth talking about as an example of how the court is attempting to keep legal proceedings fair.